Hello, I'm Floyd Stokes, your instructor for AJ3, Introduction to Corrections, at College of the Redwoods. These series of PowerPoint videos are meant to give you an overview of each chapter of the text, but you will still need to thoroughly read each chapter. Today I want to discuss Chapter 13 of our text, which is titled Juvenile Corrections. This chapter has 7 learning objectives. 1. Outline the development of the juvenile justice system. 2. Explain the age limits and types of offenses handled in the juvenile justice system. 3. Describe the juvenile court process and the characteristics of juvenile offenders. 4. Explain how juvenile offenders may be transferred to adult court. 5. Describe community-based treatment programs for juveniles. 6. Describe juvenile residential facilities and treatment programs available in them. And 7. Summarize issues confronting juvenile corrections. There's a lot of topics to cover in this chapter. So let's get started. The text starts Chapter 13 on page 223 with this quotation from Frederick Wines, Secretary of the Illinois Board of Charities and a noted penal reformer. To quote, "We make criminals out of children who are not criminals by treating them as if they were criminals," unquote. Do you believe that statement? Juveniles, and that is, of course, youth younger than age 18, account for about 26% of all persons arrested for property offenses and about 16% of all arrests for violent crimes, including murder, forcible rape, robbery, and aggravated assault. There is a clear link between age and criminal behavior. The text on page 224 describes that link as age-crime curve, which refers to the tendency for offending to rise during adolescence, peak at around age 18, and then drop thereafter. The text also describes another term, parens patriae, which is the idea that the court is the ultimate parent of all minors and therefore has the final responsibility for its younger citizens. Let's take a look at how the text deals with the development of the juvenile justice system. A separate system of juvenile justice did not appear in the United States until around 1889, when the first juvenile court was established in Chicago, Cook County, Illinois. But as the case with other justice functions in this country, the philosophy actually came from the English chancery courts in the 1800s. The guiding philosophy of the juvenile justice system at the time it was established in Illinois in 1899 was both protective and rehabilitative. The legislators gave the juvenile court concern for and authority over a child's welfare and the need to control misbehaving young people. Prior to its establishment, there was no distinction on the age of the children in their treatment in the criminal justice system. They were just considered small, misbehaving adults. That philosophy began changing in the late 19th century as widespread interest in bringing about child welfare reforms took hold across the country, and the Cook County Juvenile Court clearly became the model around the country. Today, the control function of our juvenile courts is still care and control, but the control function is not so clearly protective and rehabilitative. Instead, there has been some movement back toward a view that at least some juvenile offenders are best handled as adult offenders. The states vary in terms of the age for which its juvenile court has jurisdiction over juveniles, but the most typical oldest age is 17. That is, adult court starts on the defendant's 18th birthday. Although the juvenile court will hear cases in which the juvenile is more a victim than an offender, for example, cases of neglect or abuse, the court's control function requires it to also hear cases involving certain behavior by juveniles. The types of behavior that can result in a juvenile court appearance include some actions that are perfectly acceptable when done by an adult, for example, purchasing and using alcohol, and other offenses that would be criminal had they been done by an adult. The text discusses 3 perceived juvenile problem areas or categories on pages 226 and 227. Neglect or abuse, in which the juvenile is actually the victim of adult neglect or abuse. Status offense, which is misbehavior that is considered wrong only because society does not consider the juvenile old enough for such activity. And delinquency offense, which is an act that would be criminal had it been done by an adult. The ways in which juvenile offenders are processed through the juvenile justice system are very different from the ways adult offenders are processed. This slide shows the juvenile justice system case flow, and it is the same as figure 13.1 on page 225, but is somewhat difficult to understand. So let's take a look at another slide that perhaps explains it better. In California, a juvenile arrest is called an apprehension. When a minor is held in custody, the first hearing the minor will have is called a detention hearing, which is held to determine if the youth should stay in custody, usually juvenile hall, pending outcome of the case. Unless the crime committed by a juvenile is really serious, the juvenile is first dealt with in an informal manner, with diversion the primary goal. If diversion doesn't work, or if diversion is excluded by statute, the youth is prosecuted in juvenile court with a judge presiding and with no jury. The trial is called a jurisdictional or adjudication hearing. Many of the same rules apply in juvenile court as in adult court, except there are no juries, only judges, and things are conducted in a more relaxed manner. Both sides can present evidence and make legal arguments. The prosecutor must prove that the minor committed the crime beyond a reasonable doubt. If the judge determines that the charges have been proven beyond a reasonable doubt, the next hearing will be the dispositional hearing, where the judge decides what will happen to the youth. The options are from probation to a period of time in juvenile hall to a residential facility to California Youth Authority or CYA. Youths are only sent to CYA for violent or repeat offenses, which means, of course, that they spend time in CYA and are then sent to prison as an adult, and in that circumstance they are already primed to be a violent adult prison inmate. Youth come to juvenile court officials' attention mostly as a result of police contact, but also through social service agencies, schools, parents, probation officers, and victims. Upon getting a referral, an intake officer, prosecutor, or judge decides whether to handle the case informally or formally. The informal response involves a non-judicial disposition that is referred to as a non-petition case. The youth would then be placed on informal probation. Upon the voluntary agreement of the child and his or her parents, the juvenile agrees to submit to certain probation conditions without being formally charged or adjudicated as a delinquent. Typically, juveniles are placed on informal probation only when they have admitted to the charges against them, and they and their parents have voluntarily agreed to submit to the conditions of the informal probation. If the juvenile fails to comply with the conditions of informal probation, or if the case is handled through direct prosecution, it becomes a petitioned case, and the juvenile court process I previously described would begin. The text discusses the characteristics of juvenile offenders on page 228. It is interesting to note that females make up about 27% of the delinquency case load nationwide. Tables 13.1 and 13.2 on page 228 show a comparison of and changes in delinquency cases through 2007, and it points out that most juveniles processed through the juvenile courts are white youths for property offenses, but black youths are disproportionately represented, especially for crimes against persons. The proportion of females has increased steadily over the last few decades. As the text points out on page 229, juvenile courts were established without adversarial proceedings, and concern about the lack of procedural protection for juveniles did not get much attention until the 1960s. The banner across the top of pages 228 and 229 is important as it lists key events in the juvenile justice system from when it was first established in 1899 to the Graham versus Florida case in 2010, which is discussed at the very end of this video. One of the two key events was the 1967 case N. Ray Galt, in which the U.S. Supreme Court identified minimum due process requirements for juvenile courts to follow in cases where institutional commitment was possible. The court described four basic rights given to juveniles: the right to fair notice of the charges to allow sufficient time to prepare a defense, the right to be represented by counsel, the right to face their accusers and cross-examine witnesses, and the privilege against self-incrimination. The rights not given by the Supreme Court were trial by jury, release on bail, and protection against double jeopardy. The second key event was the 1970 case N. Ray Winship, which dealt with burden of proof, requiring that juvenile delinquency hearings required the same burden of proof as adult hearings. Hearings that were civil in nature required a preponderance of evidence. Hearings that were criminal in nature required proof beyond a reasonable doubt. The text discusses due process and burden of proof in detail on page 229. Responding to the rise in juvenile violence in the 1980s and 1990s, states increasingly allowed juveniles to be transferred to adult court under certain circumstances. That transfer occurs in one of three ways: judicial waiver, direct file, or statutory conclusion. Here are some key terms to consider. Judicial waiver is when a juvenile court judge waives jurisdiction in the matter, and it is the one most commonly found across the country, although it is used less often today than it has been in the past. Direct file is when the prosecutor decides to try the juvenile as an adult. Statutory exclusion means that criminal courts have original jurisdiction for certain crimes committed by juveniles. In a juvenile blended sentence, the juvenile court judge can impose both juvenile and adult sanctions on certain categories of serious juvenile offenders. Criminal blended sentences refers to cases where a juvenile is tried as an adult and the criminal court judge can impose juvenile sentences that would ordinarily be available only to juvenile court. Information on juvenile offenders in adult court and blended sentencing can be found on pages 230 through 233. A discussion of community-based treatment programs for juvenile offenders starts on page 233. The most frequently used community sanction on adjudicated juvenile offenders is probation. As part of their probation, juveniles may also be required to participate in such programs as drug counseling or community service. The most successful community-based programs are those emphasizing family interactions. Two good examples of such programs are functional family therapy, which is an effective short-term intervention program targeting youths aged 11 to 18 who are facing problems with delinquency, substance abuse, or violence, and multi-systemic therapy, which is an effective family-based program for serious juvenile offenders that views the individual as part of a complex network that includes families, peers, schools, and neighborhood. Juvenile community corrections programs, which are discussed on page 234, are very similar to adult programs. Juvenile residential facilities and the treatment programs available in them are discussed on pages 234, 235, and 236. Juveniles who are placed outside the home are generally sent to a group home, a camp, or a correctional facility. Most of these residential facilities are small and private, but the large public facilities are where most juvenile offenders are held. Youth in these facilities are less likely than their peers to have been enrolled in school, and many of them are functioning below grade level. Most facilities respond to this situation by providing educational services in the facility. Offense patterns of use in custodial facilities show gender differences, wherein females are more likely to be in custody as a result of a status offense or simple assault. Although effective institutional treatment programs such as cognitive behavioral therapy and aggression replacement training are clearly needed, one state has undertaken a bigger change than mere program implementation. The Missouri model, which was implemented in the 1970s, is a model for juvenile institutions that emphasizes rehabilitation in small groups, constant therapeutic interventions, and minimal force. The juvenile justice system as a whole is confronted with questions about the need for due process rights when processing juveniles, the appropriateness of transferring juveniles to adult court, and the desirability of applying adult sanctions to juvenile offenders. Particular concerns for the corrections component of the juvenile justice system include the high number of American youth in confinement compared with the youth of other countries, and the type of treatment they receive in those custodial facilities. Two issues of particular note are the disproportionately high representation of minorities in all aspects of the juvenile system, which is referred to as disproportionate minority contact, especially in residential facilities, and the consequences of applying a system designed for boys to an increasing number of girls. Girls face specific risk factors because of their gender that can derail or delay their healthy development. Girls are 3 times as likely to have experienced abuse. Girls need programs that help address feelings of anger and frustration, address reluctance to trust others, and where they can learn how they can develop and maintain appropriate, healthy boundaries in relationships. A special concern for girls is substance abuse, teen pregnancy, poor academic performance, and societal factors. There is a need for the development of gender-specific programs for girls and a need for staff to have special training in the handling of girls. These two issues are discussed in details on pages 237 and 238. To summarize this chapter, the first juvenile court was established in Cook County, Illinois, that's Chicago, in 1899 and operated under the parens patriae philosophy. Most states have an upper age limit for juvenile court as 17, and juvenile courts handle both status and delinquency offenses. Cases enter the juvenile court primarily through police referral and can be handled either formally or informally. The 3 ways a juvenile may be transferred to adult court is judicial waiver, direct file, and statutory exclusion. Probation is the most common sanction for juvenile offenders, and they may be required to participate in community programs as part of their probation. Juvenile residential facilities vary in size, and education is one of the primary programs. There are many issues confronting the juvenile corrections system, including disproportionate minorities, girls in a system designed for boys, and high numbers in confinement compared to other countries. Before I close, be sure to read page 239 of the text that discusses the case should juveniles receive a life sentence. Well, that's it for now. We'll see you in class.